Hello to our viewers. I'm excited to be joining you today. I am Dennis Masango, the manager of the Legal Aid South Africa call center, and I will be taking you through Section 34 of the Constitution today, our right to have access to courts. This is our 6th Facebook Live broadcast focusing on human rights this month. March is Human Rights Month, and we are using this time to spread awareness of our human rights and answer any questions you have about your rights. You can leave comments or questions about human rights below. If you cannot respond today during this video, look out for a message from us or response in a future video. If you require legal advice, you can basically call our toll-free advice line on 0800 110-110 as indicated behind me, weekdays between 7 a.m. and 7 p.m. If you cannot call, you can send a please call me at 079-835-7179 and we will call you back. And like and share this video to spread the word on human rights. Thank you very much, and I hope you are going to enjoy this presentation, and we welcome your engagement. And as we initially stated, in the right to access to court, it's a fundamental right that is basically engraved in our Constitution in a Bill of Rights. Section 34 basically means that all the rights about accessing the courts for individuals within a specific context are contained in terms of the Constitution. You must understand that in any democratic and constitutional dispensation, there are always disputes. And all those disputes must be resolved within the confines of the law. And if they are resolved within the confines of the law, it means every person have to have access to the courts. And therefore, the access to the courts means that so much that it's important that it's been entrenched in the Constitution. The drafters of the Constitution made it a point because it is so important that they should insert it in the Bill of Rights. And when you look at the Constitution itself, Section 34, which states, I will quote it verbatim as it appeared in this book, which is the Constitution. I hope you have one of them in your bookshelf. It's very important as a citizen. I'm going to quote this so that you understand it very clear, verbatim. Section 34 of the Constitution is contained in Chapter 2 of the Bill of Rights. It reads as follows. Everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court or where appropriate, another independent and impartial tribunal or forum. Why it's so important? And it's very clear when you dissect and analyze the concept and the clause in the Constitution. It says in a public forum to resolve issues governing the disputes that are in flout of the law. So this thing must be done in the public, in the open space, before a court of law or any appropriate forum. What it means, therefore, every individual that wants his dispute to be adjudicated upon must and should have access to the courts. The reason for establishing the courts is to avoid a scenario where each and every person takes the law into his or her own hands. So the courts are there to adjudicate. Now, there's a perception there that the courts are not accessible. The courts can only be accessed by the rich people. The courts can be accessed by the people who are staying in the urban areas. There is a challenge, basically. Those are the challenges that are experienced in terms of accessing the law or in terms of accessing justice, because accessing the courts is similar to accessing the justice. You cannot have justice if you cannot access the courts. Basically, the two are intertwined. If you want justice, how do you find justice? By going to the courts. And now, if you go to the courts, basically it means, therefore, your issues should be appropriately adjudicated by a competent person in a structure that is lawful, sanctioned by legislature, and entrenched by the Constitution. Now, what do we mean by access to the courts? We know historically that courts, in terms of geographically, were concentrated and built far away from a majority of the people. Most especially those who are disadvantaged, those who did not have access to resources, so they could not access the courts. They had to travel kilometers, either by foot, to go to the nearest court, which is about 30 kilometers. Now, how do you access justice if you cannot access the courts? How do you get justice if you don't access the courts? So those are the basically problems that emanated earlier on. However, because the country was in transformation and the Department of Justice and Correctional Services, which was then Constitutional Department of Constitutional Affairs, what it did previously, started a process of opening up courts and bringing them closer to the people so that people can access the courts. Accessing the court, it means you can not struggle to go to the court because the finances also, going to the courts, it's very expensive. You have to take sometimes double taxes. When you don't have money, how do you expect to go to court? When you have received as a witness in a court of law, a subpoena to attend a court, or if you are an accused to attend a court, the challenge is sometimes you don't have money even to go to court, which is far away. And at the end of the day, if you don't pitch up in court, the presiding officer will issue a warrant of arrest for you not appearing in court. Now, you can be basically found yourself in foul of the law. Now, therefore, it means justice is not served. Why? Because you did not have access to the courts. Now, it becomes a difficult scenario. Now, the government, in terms of the department, has moved courts closer to people where they are, where they've reduced the burden in terms of the finances of going to the courts by paying double in terms of transportation. That's one aspect of having tried to access the court in terms of reducing the geographical state of where the courts are situated. Another aspect of trying, basically, that is a barrier to accessing the courts, the finances, which is linked to the initial one. The finances, because in terms of paying your legal representative, legal representative in the form of attorneys and advocates, which are legal practitioners, indigent people, unfortunately, they are unable to afford. Now they want matters to be adjudicated upon, and to find that the forces are not the same, and the other party has basically a well-groomed and experienced counsel, and the other party does not have. Now, is that not amounting to an obstacle for a person to get justice? It doesn't amount for a person to access the courts. And it becomes difficult because the Act clearly says that your matter should be held in a public forum. Now, if your matter is held in a public forum, and as an indigent, you are unable to express yourself in that public forum, is it not access to the courts deprived and denied? It becomes that particular point of view that your access to the justice is denied, basically, because the bargaining power between you as an indigent person who cannot afford an attorney, it's basically diminished. Let's, for example, there's a scenario that has taken place where most of the financial institutions, what they normally do for a mere debt of 7,000 or 8,000, instead of taking a debtor to the magistrate's court, they will take the matter to the High Court. and then proceed in the High Court. And when the debtor receives the summons and is intimidated by the High Court, the name of the High Court itself is very much intimidating. And how is the person going to access the court? Because if you need to access the court, you need to defend the matter and file papers. And to defend the matter and file papers for a mere amount of 7,000, you need a legal representation. Because if you go to court on your own, the judges will advise you to find basically a legal representation. And if you go to an appropriate forum, for example, like Legal Aid South Africa, we have certain means tests that we conduct. We'll find out that you are working and you are earning more than our means test, which is more than 5.5 per month, which you could not qualify. But you are in the middle. You cannot afford to pay an advocate. You cannot afford to pay an attorney. You have to represent yourself in court. And unfortunately, we come back to the issue that I mentioned earlier. The bargaining power is different. The other party, because of the financial muscles, they've got quite a lot of money. They can basically hire expensive counsel. Now they have to recoup those fees that they pay counsel from you as an indigent. They add added cost. So now, how do you therefore find justice in such a scenario? How do you have then access the courts? Is it not that your right to access courts is being impeded? It's being the obstacles for you basically to be heard in an open and a transparent manner. So those are the issues. And this has come up in some matters, and the judges have started in some cases to say, no. This tendency of the financial institution to take their debtors, to take their clients in the High Court for smaller amount, and therefore in terms of the fees that they charge or in terms of the cost that the court grants them should be paid by the debtor instead of them going to the magistrate's court, which is nearer most of the time and nearer to where the debtors are staying. We've got a lot of magistrates court around in the country compared to the high courts. High courts are not geographically spread in various towns. There are specific high courts in different towns, but not all of them. But the magistrates court are each and every most of the towns they are there. Now, if the debtor has been sued in a magistrate's court that he resides, basically that becomes easy. And now it also points to the issue of in the High Court to battle in a civil matter to get an interpreter or a translator. It becomes an obstacle. But in the magistrate's court, interpreters and translators are always there. So it becomes easy for one to access the courts. So now the courts are trying mostly to say, we want to discourage the situation where the banks are coming to the High Court to claim smaller amounts, which they can do in the magistrate's court. So in a bigger picture of schemes, access to courts is very much important. Why it's important? It gives a platform for another person to basically put his case or her case before the presiding officer without any obstacles. So each and every individual, in fact, is open to approaching the courts without any obstacles, without any impediment. They are able to go to the courts and say, I am here, I can represent myself, even if it's in the magistrate's court, because there's an interpreter here who understands the language that I'm able to expose. Because language, let me be clear with you, it's also an impediment. It can make you, it can make the process very hard. It can make that the impediment to be stronger for you to access the courts. Mind you, if you go to a place or a court where you cannot speak the language, how do you basically understand the proceedings? It becomes difficult. They speak either English or they speak Afrikaans. Now, the Constitution is very clear that it must be made sure that the proceedings are conducted in the language that you understand. If they cannot be done so because of logistical reasons, therefore it means an interpreter must be procured so that he can interpret and make it understand for you the legal jargon in the language that you understand very clearly. So now it becomes easier now because you are able to access the courts and you conduct the proceedings in the understanding and the language that you understand. So what does it mean, therefore? It means because sometimes you can lose a case, either in a civil or a criminal matter, because somebody did not understand the proceedings, you know. And sometimes it's important that even if there are interpreters, the quality of the interpreters is very much paramount. Because if there's no sync and the understanding, because you don't understand the language as either an accused or a civil litigant in a particular matter, you rely and depend on the interpretation, which sometimes along the process, you might basically lose the interpretation. And sometimes you lose a case because you don't understand, but you have merits, but because you did not understand the proceedings because of the issues of interpretation. So that is not the case that therefore your right to access the courts has been compromised, because there should not be any impediment at all for you to access the courts. Obviously, when you look from international jurisprudence, it is very clear from the United Nations Declaration of Human Rights and the African Chapter and African Union Chapter on Human Rights that every individual has the right to access the courts. And that any issues that wants to be ventilated, it should not basically be stopped from approaching the courts. Therefore, only obstacles that are there that impede people from approaching the courts should not be. I think the government has done very well in terms of opening up various courts. We've got quite a lot of courts in various ways. We've got the Constitutional Court, which of lately, when it started, it only dealt with constitutional issues. You could not directly refer matters to the Constitutional Court. However, because it became clear that because of that, you have to start at the High Court, you go to the Supreme Court of Appeal, therefore you have to go to the... By that time you arrive at the Constitutional Court, you have exhausted all the funds. You don't even have the funds, in fact, to reach the Constitutional Court. But in terms of development into our legal jurisprudence, the Constitutional Court find it very convenient and said, we can now have direct access on specific matters to the Constitutional Court. Citizens can have direct access to the Constitutional Court on matters that have merits, on matters that the Constitutional Court can decide. Now, that is very important, that it gives access to courts for people to basically bypass the High Court and bypass the Supreme Court so that they can have their matters ventilated. Even if they don't have money, even if they don't have resources, they're able to budget for a Constitutional Court application only, instead of from High Court to the Supreme Court of Appeal and to the Constitutional Court at the end of the day. So we have various means where people can approach the court. We have the magistrates' court, which are nearer to the people where they stay. We have community courts, which are based mostly in the Western Cape, which deals with minor issues. That is access to justice and access to the courts. So it's one platform of engaging the people and say, we are bringing justice closer to you. And we are here saying, here are the courts, you must access them. And then various aspects in the courts. Those who want to use the high courts, we've got high courts, we've got Supreme Court of Appeal. There are various mechanisms that can be used to access the courts. We've got specialized courts, for example, income tax courts. We've got commercial crimes courts. We have CCMA tribunals, any other tribunals that you can access, basically, to do what? For your rights to be expedited, for your matters to be heard. So no one who wants to ventilate his legal dispute is barred from doing so. There are various mechanisms, there are various courts in our country that are open if you want to litigate, for you to go and basically either defend or institute an action. We've got from the labor court, we have a labor appeal court that deals with specifically issues of labor emanating from the CCMA, where you want to basically to resolve all your issues being litigated upon and heard in a proper platform. Those are measures that people should have access to courts, so that people don't take the law into their own hands. So that if there are issues that are involving the law, there are various structures that are there that can assist people. We've mentioned about the barriers. Well, Legal Aid South Africa is there to those people who are unfortunately are unable to provide finances to get private attorneys. We are there, we provide services that we provide in terms of legal representation, we provide services in terms of legal advice, and we provide services in terms of legal education. So if unfortunately we are unable to, it's not as if it's lost, because if you don't have access to courts, basically, and it means therefore the rule of law is not seen to be done. It is very clear that justice must not only be done, it must also be seen to be done, so that it cannot be so said if you don't have access to courts. You know, how do you resolve your matters if you don't have access to court? How do you access the courts if you don't have the financial muscles to do that? How do you access the courts if the courts are staged or are created far away from where you stay? So those obstacles, obviously, they inhibit you from accessing the courts. However, as I've stated earlier on, the government is trying at all costs to bring access courts to nearer to people where they are staying. You can see the high courts, although they are not everywhere, but there are periodical courts, and they are brought sometimes on a monthly or bi-monthly basis to where people are, where the high courts are not situated, so that people don't travel quite a long distances, so they can be able to access the courts so that their matters could be ventilated. So it's important that you exercise those rights, because if you exercise those rights, don't take the law into your own hands. That's why Section 34 is there, and that's why it must be utilized. It's important that you go to the courts, ventilate your issues in the court. If you're not happy about the services, you must raise those issues. If you're not happy about, you don't understand the documentation of the process, raise those issues, because you have Section 34, as I've read it to you, it says those issues that involve the law and the dispute that involve the law, they must be heard in the public. When we say access to the law, you must understand also our legal jurisprudence is developing in a rapid, you remember the case of Oscar Pretorius. That is also part of access to justice. It's part of access to the courts. There are people who want to follow up with what is happening, and they are basically sitting at their comfort zone and looking at what is happening in the courts. So access to justice does not mean that you as an individual who is also involved in litigation, you only have to access. As members of the public, they are able to access how the justice function, how the courts function. Now it opens up how a lot of people did not understand how the justice functioned before the Oscar Pretorius case, before the Motoso case. Now it means the public has a benefit of accessing the courts through opening of the courts through the television, through the media, through live streaming in the video, everywhere you are, whether you are in Europe or whether in Africa, you can see that the courts are opening up in South Africa. Justice is opening up in South Africa. People know in terms of education about what is happening in the courts. Is it not access to the courts? Is it not you see the functioning of justice right in front of your eyes? So therefore, if you find it difficult that you don't access to courts, you have to basically go to your nearest courts and basically request further information. Or alternatively, if you need further information, you see the number behind, which is Legal Aid South Africa. you can consult us and at 0800, as I've stated, 110 110. And initially also when I gave you the number where you can send your please call me, you can further elaborate on what is basically meant to access to justice. You might have basically accessed the courts. You might not have, it happens, you might not have found solace in the courts because maybe the officials of the court did not treat you very well. But it does not mean that there is no justice in our courts. And what I'm telling you is that if you are not happy about the outcome, because what is important is that if you access the courts, your matter is deliberated according to the Constitution. That's what is important, is that your matter is held in public and a decision is arrived at, which might not be in your favor. It does not mean that you did not have access to justice. It does not mean that you did not have access to courts. You must understand that we live in a constitutional dispensation. And in other countries, they don't have access to courts. They don't have access to justice. Justice is meted out in the street. But here in this beautiful land of ours, it's in the Constitution, it's here. It says whatever dispute you have, it must be ventilated in a court of law. In a court of law. Let me refer you to a case that came before the Constitutional Court. The importance where the Constitutional Court entrenches the importance of Section 34. You remember the case where the Judicial Services Commission was interviewing judges for appointment to the bench. And there were senior counsels that applied from Western Cape, and it was the third time that were not appointed. And they basically, through the Helen Suzman Foundation, took the Judicial Services Commission to the High Court. And they said, no, is it because the person is white, the advocate is white, because he's not appointed? They wanted to know what were the reasons for not appointing. And obviously, when you go in terms of the rules of the High Court, they go to Rule 53, which says when you review the decision of the tribunal, remember that initially we talked about a forum and a tribunal. And then the tribunal that took a decision must provide reasons, basically. So, and when the Helen Suzman took the matter, the Judicial Services Commission, to the High Court, and they wanted the recordings of the reasons for not appointing senior counsels who were white by that particular time. They refused. They said, no, we cannot give you those records because those are confidential discussions of the panel. The process was open. It was a transparent process. We questioned the candidates, but the decisions that we took and deliberations are not open to the public. Then the High Court agreed with the Judicial Services Commission. Helen Suzman Foundation was not happy about that. They took the matter to the Supreme Court of Appeal. However, the Supreme Court of Appeal took a middle ground and said, although the information cannot be divulged because of the nature and the sensitivity of the deliberation, some of the people might be deterred in future from coming up if they know the reasons. So each and every particular case must be attended on its own merits. So the merits of this particular case, we believe that the record should not be released. But in a sense, records should not be withheld, but depending on the specific case. So this case was records should not be released. Helen Suzman were not satisfied foundation, they took the matter to the Constitutional Court. Remember, the Constitutional Court is guided by this document, the Constitution. This is the last and the guiding, and the Constitutional Court is the interpreter and the guidance of this document. Constitutional said, no, Section 34 is very clear. Each and every dispute must be ventilated in an open court or open forum. Now, how can the applicant, which is Helen Suzman Foundation, file its papers in the Constitutional Court if it does not have record of the deliberations. It can file papers which are half-baked, and the other party knows what transpired, but they don't have the benefit of what transpired. Therefore, that defeats the purpose of access to the courts. So how can they access the court if they don't have information? So those recordings are very much important for them to ventilate their case. Therefore, in that particular instance, the court quoted Section 34 and said it's very clear that for the matters to be ventilated and dispute to be resolved, and in a public manner, access to information is important. So those two are linked, access to information and access to court. You cannot exercise your rights in a court of law if you don't have access to that information that gives you right and empowers you to file certain applications. Basically what it says, therefore, the court said, no, the Judicial Services Commission must give the recordings of the deliberations when they made the decisions, so that they can be able to challenge those decisions, effectively knowing very well what transpired. Why I'm quoting this case, it's important because it gives access to courts. How do you access the court if you don't have information? How do you ventilate your case if you don't have information? So information is part of accessing to courts. When I'm drafting an affidavit, I draft an affidavit or pleadings based on information that I have. But if I'm denied information, how do I draft papers? I can initially draft papers pending provision of information. When I subsequently get that information, then I can make amendments and supplementary affidavits to my initial documentation because there were information that was lacking, now I've received. So basically, I'm emphasizing the importance of access to courts as indicated by the Constitutional Court and said, no, Helen Suzman Foundation is entitled to the recordings of the Judicial Services Commission when they deliberated and made a decision not to recommend appointment of a senior counsel. So it's important that if you need further information, and please contact us. And as I've stated, and thank you for joining us today. And if you have any further questions, you can send us a Facebook message, or if you require legal advice, you can call us on our toll-free number. You can see it here. It is 0800 110 110, and weekdays between 7 a.m. and 7 p.m. in the evening. And if you cannot call, and you can always send us a please call me, 079 835 7179. And we will call you back. Make no mistake, we do call people back. Join us again next week as we discuss our rights to information, just administrative action, and housing. Check it on Facebook to find out when this conversation will be taking place. Send us your questions, and remember to like and share this video to spread the word on human rights. Thank you and goodbye. Adios, amigo.